Ms. Bonjean, do we know, though, that the district court actually relied on that? Because the district court said, I could find by a preponderance that he obstructed justice. And there was no specific finding that he did. Yeah.
I don't think any circuit has sided with your position. You're right. Yeah, that's correct. But
do you want us to infer from that he actually did? Well, and what's the basis to do that, given the judge's specific comments?
I don't think any circuit has sided with your position. You're right. Yeah, that's correct. But
the district court sentencing seemed very grounded in the 3553 factors and his concern for the seriousness of this offense and your client's history and characteristics, which is exactly what the courts must do, is look at the 3553 factors. How do you get around that? Well,
I don't think any circuit has sided with your position. You're right. Yeah, that's correct. But
it's not determinative. The court has to look at 3553, which again, the court spent quite a bit of time on those factors, in particular, the seriousness of the offense, the need for deterrence here, protecting the public.
I don't think any circuit has sided with your position. You're right. Yeah, that's correct. But
is not borne out at all. In fact, the jury affirmatively rejected the government's narrative.
Different burden of proof.
I don't think any circuit has sided with your position. You're right. Yeah, that's correct. But
does your client realize he could end up worse off? Because the court did go above the guidelines, but very significantly, only 1 year is consecutive to the sentence that your client received in New York. So theoretically, if it's remanded for resentencing because of an error, and the court gives a guideline sentence, which is what you seem to be arguing the court should have given, that entire guideline sentence could be consecutive, or half of it, or more than a year, which would put your client in a worse position. So does your client realize that?
Yes, Judge.
I don't think any circuit has sided with your position. You're right. Yeah, that's correct. But
I just want to make sure your client understands that if he wins on this particular point, he has risks. That he might get a higher consecutive sentence.
Yes, Judge.
I don't think any circuit has sided with your position. You're right. Yeah, that's correct. But
the judge certainly could. If it's sent back for resentencing, the judge could start over and look at everything. So to say it would be retaliatory, there's no grounds for that, or no case law that would support giving a higher sentence or a sentence that would have a more significant consequence.
Well, I don't
think any circuit has sided with your position. You're right. Yeah, that's correct. But
and obviously we would acknowledge that some of these circuits have already sided with the government's position on this. The issue's in front of the Second Circuit presently. So
I don't think any circuit has sided with your position.
You're right. Yeah, that's correct. But perhaps there will be a split at some point. But our position is that the U.S. Supreme Court would see this differently in light of those general principles, and that we need to start there. And I think the court is well equipped with the information that we've provided and the government's provided to make that decision. I want to get back to this obstructive conduct very quickly.
I don't think any circuit has sided with your position. You're right. Yeah, that's correct. But I don't think any circuit has sided with your position. You're right. Yeah, that's correct. But I don't think any circuit has sided with your position. You're right. Yeah, that's correct. But I don't think any circuit has sided with your position. You're right. Yeah, that's correct. But